Hi everyone, thanks for joining us today. I'd like to start with an acknowledgement. I'm in Meanjin today and would like to acknowledge the traditional custodians of the land on which we live and work, the Turrbal peoples from the north side of the river and the Yuggera peoples on the south side of the river. And we pay our respects to elders past, present and emerging, always was and always will be Aboriginal land. I'm Janelle Fawkes and I'm the campaign leader of DCRIM-QLD. DCRIM-QLD is the group of sex workers throughout Queensland who have joined with Respect Inc., Queensland's sex worker organisation, to progress the removal of harmful laws and discriminatory sex work laws, really, and achieve decriminalisation in Queensland. So thank you so much for joining this lunchtime research brief. It's based on a paper. I wouldn't call the cops if I was being bashed to death. Sex work, core stigma, and the criminal legal system. The event is brought to you jointly by the QUT Centre for Justice and DCRIM-QLD. And we're very lucky today to have two of the authors with us. They are Dr Zahra Stardust from QUT and Jules Kim, CEO of Scarlet Alliance, Australian Sex Workers Association. So the format for today is that I'll invite Zahra and Jules to provide us with a short presentation, and then we'll move on to discuss the paper with a specific interest in how the findings relate to our experiences here as sex workers in Queensland. So to head off, we'll ask Dr Zahra Stardust, who is a socio-legal scholar at the intersections of sexuality, technology and law. She is currently a postdoctoral research fellow at the ARC Centre of Excellence for Automated Decision-Making and Society at the Queensland University of Technology, and an affiliate at the Berkman Klein Centre for Internet and Society at Harvard Law School. Her current projects examine the data governance of sex tech and implications of algorithmic sexual profiling, and how content modernisation practices impact sexual cultures. Over the last 15 years, Zahra has worked in policy, advocacy, legal and research capacities within community organisations, NGOs and UN bodies on sex worker rights and LGBTIQA+ health. Her work has been published in books such as Queer Sex Work, New Feminist Studies and Orienting Feminism, and journals such as the Journal of Sexual Health, Porn Studies, and the International Journal of Crime, Justice and Social Democracy. Welcome, Zahra.
Thank you so much, Janelle. Just going to share my screen with everybody. One moment. Great. Well, thank you so much for having me. I'm also here on the land of the Turrbal and the Yuggera people, unceded and stolen land, and pay my respects to all Aboriginal and Torres Strait Islander people here in the room with us today. Today I am going to be presenting research that we recently published. It's free to download, it's open access, and I encourage you all to take a look. I put a link in the chat for you. This research is actually part of a broader stigma indicators monitoring project, which was a partnership project between Scarlet Alliance and the Centre for Social Research and Health at the University of New South Wales. And the overall project looked at how to identify a measurable, quantifiable indicator of stigma and discrimination for Australia's national STI and HIV strategies. It was part of the sex work component, was part of a broader project that looked at stigma in relation to gay and bisexual men, people who use drugs, and people who are incarcerated, among other priority populations. So our project aimed to look at what sex work stigma looked at like across Australia. And to do so, we began with a series of qualitative focus groups on stigma with sex workers around the country. We knew that there was previous research on this topic from about 20 years ago with Scarlet Alliance and FAO. And in order to update that research, we then held a focus group, a workshop among about 100 sex workers at the Scarlet Alliance National Forum in 2016 to identify the themes and topics for our focus groups. And then we then conducted national focus groups in every state and territory with around 31 sex workers of a range of different genders, sexualities, racial and ethnic backgrounds, ages, and types of sex work. It was a broad project, so we were looking at multiple manifestations of stigma across areas of service provision, institutions, family and relationship, housing and accommodation, and representation in media. But today I'm going to be talking about one particular aspect of that research, which examined sex worker attitudes and interactions with the criminal justice system. So we had a lot of data about sex workers' relationships with police, the likelihoods of reporting crime, barriers to pursuing justice. And I want to issue a warning at this, just a content forecasting at this point, that some of the material that we will speak to does speak about sexual assault and the murder of sex workers, as well as police violence. A few things about stigma just before we begin. We took a theoretical approach that was informed by literature that recognises that stigma is a barrier to effective health promotion and to human rights. It's something that discourages people from accessing justice avenues. We thought about sex work as a crime against convention, something that is consensual activity that's often criminalised because of its deviation from social norms. And we had previous research that indicated that stigma operated at macro levels in the forms of laws, policies, regulation and media, meso levels in the forms of institutions like justice and health systems, as well as micro levels, including among sex workers and from the public. But the first thing I want to speak today is the ways in which our participants in our focus groups were highly reluctant to seek police assistance if they were victims of crime. And this was the case for crimes experienced in sex industry workplaces, but also crimes experienced by participants in their outside work life. Migrant sex workers in particular reported incidents in which police would arrive at their workplace with an unspoken expectation that they would receive free services in return for not reporting their businesses. Participants also recalled occasions where clients had assaulted them in the workplace and the police officer attending the scene justified and then minimised that client's behaviour and then threatened to report the sex worker to immigration. And for sex workers who are on temporary visas, the incentive to report crime was low because of the likelihood that police might tip off immigration authorities. So sex workers feared deportation or losing their job, and so police involvement was seen as an additional risk. Participants also recounted instances where police had repeatedly tried to get sex workers to admit to services that were illegal. And this is an account from one sex worker in Queensland who had an undercover police officer pretending to be a client, attempting to get her to agree to a range of unlawful activities, and then pretending to have left his wallet in the car and never returning. And she describes this situation as being incredibly unnerving and distressing. Participants also reported that their interactions with police shifted dramatically if they disclosed their sex work. So for this person who wanted to report an assault to police, said it's just like everything's going along, you're being treated with respect, and then you just click your fingers and all of a sudden everything is different. I was just treated with no dignity, no humility, and no respect. Participants also reported that they were more likely to seek police assistance for serious crime, seek police assistance in any event, no matter how grave. In one participant saying, I wouldn't call the cops if I was being bashed to death. These participants reported previous inaction by the police and also pointed to a well-documented history and ongoing culture of police brutality towards marginalised groups such as queers, sex workers, drug users, trans and gender diverse people, homeless people, and their lived experience was very much, they don't care about us. Others spoke to a culture in which police were oblivious or reckless about their presence in community spaces and the possibility that that might be triggering to people. So, for example, this participant spoke to the impact that police have on sex worker communities when they turn up to events in full uniform with guns and tasers. And this worker reported, it's just bizarre to think what kind of public imagery they want. Do they want a public image where everyone's too frightened to talk to them? Because that's pretty much what they do. Sex workers' reluctance to report crimes was compounded by a sense of trepidation about navigating the court process if they were to pursue matters. So, like other victims of sexual assault, sex workers were reluctant to report such crimes to police, anticipating that if they proceeded to trial, their credibility would be questioned in cross-examination, and this echoes very well-documented research of experiences of sexual assault survivors who report being re-traumatized by the court process itself. Some participants expressly noted the very high attrition rates, the low conviction rates, and the difficulty in successfully prosecuting these cases generally. So the question for them is, why would you really put yourself through this? Sex workers were also anticipated that then if there have been some cases in which they expected that the judges would not necessarily be able to differentiate between sex work and sexual assault. And this goes back to a long history in which judges have commented on the perceived rapeability of sex workers in court and presumed that sex workers are perpetually in a state of consent. Even in clear cases that had sufficient evidence, reporting could be too frightening. There has been some case law in 2015, for example, the Levers case where a sex worker, a client was successfully prosecuted after he pretended to pay a sex worker stuffed with paper of envelope, and he was pled guilty to sexual assault induced by fraud. And some participants actually referred to this case in the focus groups as an example of progressive shifts in the law. However, one participant reported that they had had similar circumstances, but they still felt too afraid to access police. These attitudes anticipate they anticipate a reaction from judiciary and from police from the framework as sex work itself as violence. And historically, case law has treated a victim's sex work as being relevant to ascertaining their level of psychological impact, especially for the determining of sexual offences. This is a famous case from the 1980s, Attorney General and Harris, where the judge stated that sexual assault when committed against prostitutes is not as heinous as when committed, say, on a happily married woman living in her flat in the absence of her husband when the miscreant breaks in and commits rape on her, because the forcible act of the sexual act itself would not have caused the same reaction of revulsion in a sex worker, which it might cause in a chaste woman. And then we have about a decade later in the 90s, another decision, Hakopian, in which the judge commented that a sex worker would experience less psychological harm because they would have been involved in sexual activities on many occasions with men they had not met before in a wide variety of situations. It wasn't actually until 2016 that the Victorian Sentencing Manual was updated, so judges could no longer take into account sex work of the victim prior to the offence, and that followed very extensive advocacy from both sex workers and women's legal organisations and the Victorian Law Reform Commission. And participants in our groups noted the overdue nature of these legislative changes. When we asked whether sex workers thought they received equal treatment under the law, participants pointed to other instances where they thought the law didn't deliver justice. Some spoke about the murder of sex workers, which had received significant media attention, including the differential media attention of the deaths of Jill Meagher, a non-sex worker, and Tracy Connolly, who was a sex worker. Others noted the Courier Mail's reporting on the horrific murder of Mayim Cressito, which was ruled offensive and gratuitous by the Australian Press Council. So participants experienced these kind of media reporting and judicial decisions as a reflection that their lives were less valuable. In one focus group, a participant referred to a 2009 case of a United States sailor who was charged with sexual intercourse without consent, who became aggressive when he didn't orgasm within his half-an-hour time slot in the brothel, and removed his condom and had unprotected sex, which he admitted to using a lockdown maneuver, and he was found not guilty by the New South Wales District Court. So participants in our groups had cases like these in their minds when deciding whether or not to report crime to police. One said, "We're constantly reminded that we're not valuable members of society and not in need of police protection or justice." So the data in this project really offers qualitative insights into the factors that affect sex workers' decisions whether or not to engage with the criminal justice system. Sex workers consistently indicated a reluctance to seek police assistance or pursue cases, a lack of trust in police, lack of faith in the criminal legal system, no perceived likelihood of a just outcome in court, and as a result took steps to avoid the re-traumatization by simply opting out of the system itself. They reported numerous barriers to justice, including the law itself, a complex web of criminal and licensing laws that continue to regulate sex work, including in Queensland, pose a very significant disincentive to sex workers having any interaction with the state. And sex worker decisions were also influenced by the legacies of police corruption and brutality towards sexual minorities. They saw police as prosecutors rather than protectors. Sex workers' decisions to pursue redress were often influenced by news reporting, also media and crime television programs that saw them as being simply the butt of a joke or as disposable victims, to high-profile court cases as evidence of the law's ability to keep pace with community standards. And the few occasions where sex workers did report positive experiences with police were isolated to individual officers at particular stations that had relationships with sex worker organisations. So this study really indicates that sex work stigma is steeped into multiple layers in the criminal justice system, from police to police corruption to prosecutorial narratives to judicial commentary, and the decisions to opt out are really decisions for self-protection. And the data indicates that decriminalisation of sex work is a first step rather than an end goal. We need law reform, but further sex work sensitivity training for police and judiciary, the building of appropriate referral pathways, funding for sex worker legal clinics, and a range of other stigma reduction mechanisms if we are to end sex work stigma in Australia. Thank you.
Thanks so much, Zahra. We're now going to ask Jules Kim to provide us with a presentation. Jules is a Korean Australian sex worker and the CEO of Scarlet Alliance, the Australian Sex Workers Association, the peak national organisation representing sex workers and sex worker organisations, collectives and projects since 1989. She is the chair for the Regional Sex Worker Network Asia Pacific Network of Sex Workers, the APNSW, and is the UN Program Coordinating Board NGO Delegate for the Asia Pacific for 2019 to 2021. Jules represents sex workers on a number of government committees and advisory mechanisms, and has provided testimony and expert advice to parliamentary hearings and inquiries in relation to sex work, migration, trafficking and law reform, and has led research on migrant sex workers. She has over 20 years experience in sex work, sex worker advocacy, community development, research and representation. Thanks, Jules.
Thanks so much, Janelle. I'm going to share my presentation. Just want to acknowledge that I'm coming to you from Gadigal land and pay my respects to elders past, present, and any Aboriginal people who are with us here today. So let's see if we can do this effectively. So, from the beginning. Okay, so as you heard, Scarlet Alliance, Australian Sex Workers Association, and through our objectives, we aim to achieve equality, social, legal, political, cultural and economic justice for past and present sex workers in order for sex workers to be self-determining agents, building their own alliance and choosing where and how they work. So sex work in Australia is governed by a complex matrix of laws, and laws vary between states and territories and between the different types of sex work. There are different laws that govern sex work, bloodborne viruses and STIs, and there are different laws between federal and state-based laws that often contradict each other. Additionally, there are no consistent anti-discrimination protections for sex workers. Currently, there are anti-discrimination protections in 4 jurisdictions, but they haven't been particularly effective and are quite narrow in their scope. In the ACT, there's protection for profession, trade, occupation and calling. However, what that constitutes is not defined in the Act. And in places where sex work is not fully decriminalised or not considered to be lawful work, this type of protection would be moot. In Queensland, Victoria and Tasmania, currently there's protection for lawful sexual activity. Though this terminology is extremely restrictive, in those jurisdictions, none of those jurisdictions are currently decriminalised, and meaning for that sex worker to use this protection, they have to be working lawfully within restrictive licensing or registration schemes that are in place. This obviously excludes the large amounts of sex workers in those states that are unable or unwilling to comply with these schemes. Both of these options depend quite heavily on the current regulatory and legal environment that surrounds sex work in that particular jurisdiction. In a political or judicial climate that doesn't consider sex work to be work, these protections wouldn't be considered to cover sex workers. Both options have significant gaps and are at the mercy of their environments. The Queensland laws also contain, well, each of those jurisdictions contain fairly broad exceptions. In Queensland, the laws are very narrow and extend protections only to sex workers who are able to work lawfully within the restrictive licensing scheme in place, and exceptions are in place for accommodation in connection with sex work, and it's also lawful to discriminate with respect to the care or instruction of minors. So what are adequate anti-discrimination protections for sex workers? It's important that the inclusion of sex work and sex worker are included as main attributes to eliminate any uncertainty or ambiguity that those who do not identify as a sex worker or are excluded from operating within the legal sex industry are covered by those protections. Additionally, it also provides protection regardless of the viewpoints or the regulatory environment or legitimate, viewpoints on the legitimacy of sex work. It provides protection for past and current sex workers and protection for associates of sex workers to ensure sex workers' fundamental human rights to freedom of association and self-determination is protected. Additionally, anti-vilification laws that explicitly prohibit offensive conduct against sex workers as a protected attribute and extend to those who currently have or have previously held the protected attribute associated with another person with the protected attribute or incorrectly assumed to possess the protected attribute are covered. And additionally, a representative complaints model that enables a collective complaints process and for organisations to submit a complaint process on behalf of individuals and for sex workers to be able to make anonymous or pseudonymous complaints. So, and why are these anti-discrimination protections so necessary? Well, we heard from Zahra the considerable barriers that sex workers experience to accessing justice and the extreme levels of stigma and discriminations that sex workers routinely face. Sex workers are routinely denied our rights to associate and organise, to be protected by the law, to be free of violence, and to be free from discrimination, our right to privacy, our right to freedom from arbitrary interference, and our right to health, and to move and migrate, and to work and free choice of improvement. Licensing and criminalisation are often direct contraventions of these rights. Licensing frameworks, like those that are currently being repealed in Victoria and those that still exist in Queensland, are sometimes misleadingly referred to as legalisation, but I think we can more accurately describe them as over-regulation. Licensing bans sex workers from working in residential areas and require us to work in isolated industrial areas and poses a threat to our safety. Licensing requires us to disclose our legal names to clients or the public, increasing risk of harassment. And it may require us to register our legal name and addresses on a permanent police or government record, which can never be removed. Licensing may also require sex workers to have forced medical testing, despite sex workers having far lower or equal rates of STIs than the general populations. And licensing means that acts which are lawful for non-sex workers, such as consensual sex between adults without a condom for oral sex, for example, or consensual sexual acts with more than one person, become unlawful and punishable with penalties for sex workers. Licensing inevitably creates a two-tier sex industry because sex workers are forced to work illegally to protect our health, safety, and rights. And a history of police regulation, corruption, and entrapment practices means that sex workers in a licensing model are less likely to seek police assistance in the event of a crime. Sex workers' human rights are intrinsically linked to our ability to negotiate with clients and access essential services, satisfactory workplace conditions, and workplace health and safety. These basic human rights that are taken for granted by most are often inaccessible for sex workers. So sex workers face a range of issues, we hear, and the stigma and discrimination is a daily experience for sex workers. In fact, in 2020, indicator measuring experience stigma was included in an online survey of sex workers in Australia as part of the Stigma Indicating monitoring project in partnership with the Centre for Social Research and Health and Scarlet Alliance. 647 people had completed the survey, and preliminary data showed that in 2020, 96% of sex workers reported experiencing any stigma and discrimination related to their sex work within the last 12 months, including 34% who indicated this was often or always occurred. Similarly, 91% of the participants recorded negative treatment by health workers, including 24% who indicated this often or always happened. Centre for Social Research and Health had previously also measured stigma towards sex workers reported by the general public and health workers. In that research, 64% of the general public and 31% of health workers self-reported that they would treat someone negatively because of their sex work. And this was self-reported stigma. So, we can assume that the levels of actual stigma were probably much higher. This year, in the United Nations Political Declaration on HIV/AIDS, the high-level meeting was negotiated with Australia as co-chair with Nigeria. In a key element in the political declaration recognised the crucial role of human and legal rights in preventing and eliminating HIV. The political declaration that had been negotiated with agreement by countries around the world committed to the rights of all people to the enjoyment of the highest attainable standard of health, and that human rights should apply to all people, including female, male, trans and gender diverse sex workers, Indigenous migrant sex workers, and sex workers living with HIV. In reality, sex workers often face high levels of harassment by police, government, and the laws, and have limited or no access to rights and legal redress, and are unprotected by the law. Stigma, discrimination, human rights abuses, licensing, and criminalisation of our work are challenges that sex workers face daily. And research shows that punitive laws, policies, and practices around sex work does not reduce the number of sex workers or our clients, but they do and can change the ways in which we work, increases our vulnerabilities and reduces our access to justice, health, and create barriers to accessing supportive services. Licensing and criminalisation has been shown to negatively impact upon health programs and services for sex workers. But by contrast, decriminalisation is essential to improving the health, safety, and human rights of sex workers. So what is decriminalisation? Decriminalisation is a framework that repeals criminal and licensing laws specific to the sex industry and regulates sex industry business through standard business, planning, and industrial codes. It doesn't single out sex workers for specific discriminatory legislation and removes police as the regulators of the sex industry. Sex industry businesses are treated like any other business, subject to existing regulatory mechanisms such as planning, zoning, location controls, workers' compensation requirements, occupational health and safety standards, industrial rights obligations. And police are not involved as regulators at any level unless there's a breach of law. Now, decriminalisation is not no regulation. It doesn't put sex workers outside of the law. Obviously, criminal laws still apply. And decriminalisation doesn't create new laws for sex workers, and it also doesn't leave specific sex workers behind. We have a mountain of evidence that shows that decriminalisation has reduced corruption and increased transparency. The Wood Royal Commission, which was the catalyst for decriminalisation in New South Wales, cited evidence showing a clear nexus between police corruption and the operation of brothels. And in the decriminalised environment, sex workers are much more likely to approach police in the event of a crime. Decriminalisation means better access to outreach, education, and health promotion. A comparative study of brothels in Perth, Melbourne, and Sydney showing criminalised licensing and decriminalised systems found that of those three Australian approaches to sex industry legislation, decriminalisation led to best health outcomes and better access to health promotion. And decriminalisation supports occupational health and safety. The New South Wales government reported a brothel task force reviewing the implementation of decriminalisation, found that it had a positive impact on workers' access to health services and workplace health and safety, and arguments for a separate licensing authority should be rejected as they identified that this was an area for potential corruption and would increase the number of sex workers working illegally. And decriminalisation has not increased the size of the industry. There's been strong evidence that it hasn't led to the increase of the industry, and the numbers have stayed, even 20 years post decriminalisation, similar to the estimates prior to decriminalisation. It is widely recognised that it is the optimal model for sex industry legislation, and there's a mountain of evidence to support that and a growing number of supporters for decriminalisation. Just finally, and there's momentum building around Australia for decriminalisation and reforms to sex industry regulation. Although not fully decriminalised in ACT, there was reform of the Sex Work Act in 2018 and a recent commitment to fully decriminalise sex work. In November 2019, the Northern Territory passed the decriminalisation of sex work, and it was implemented mid last year, making it only, only the second jurisdiction in Australia to decriminalise sex work. The Victorian government has announced its intention to repeal decriminalisation. In fact, last week it actually passed through the lower house and is about to be very soon to be heard in the upper house. Additionally, there is a bill currently before the Legislative Council in South Australia to repeal sex work offences. And also the Queensland government has also announced that decriminalisation of sex work has been referred for review and drafting of legislation. And importantly as well, an act to amend the Anti-Discrimination Act in New South Wales to include sex work and sex worker in both for anti-discrimination and anti-vilification protections is at the second reading in New South Wales. So as you can see, that there's a lot of positive momentum towards sex work, necessary sex work law reform. Thanks.
Thanks, Jules. So, and thank you very much for those presentations. They really give a great kind of overview of these issues. I'm going to take us back to the paper, and I notice with interest that the paper refers to stigma as a driving force behind many policies, including licensing, the model of sex work regulation we have here in Queensland. And you write that they are infused with moralistic presumptions, draw on the rhetoric of risk, and understanding of the labour of sex work as delegitimate, and that criminalisation and licensing of sex work are both drivers and symptoms of stigma. It's really a very important topic for us here in Queensland because, of course, how people consider sex work is going to really matter to what type of legislation we end up with drafted here. So can you talk to us a bit more about those issues?
Yeah, of course. We say that licensing and criminalisation are both drivers and symptoms of sex work stigma. So they're drivers in the sense that the presence of criminal laws, the presence of licensing laws continuously facilitate and then provide justification for increased police contact. So the more licensing laws, the more police feel justified to interact with sex workers. This then opens up opportunities for entrapment and bribery or over-policing, not just from police, but also opens it up and invites stigma from medical professionals or institutions or banking and finance, who then look to the criminal and licensing laws to justify their own discriminatory practices, which ultimately leads to worse outcomes for sex workers. So the licensing laws in Queensland are drivers of sex work stigma in that sense. But then we also talk about them as symptoms of sex work stigma in the sense that all of the legal systems that govern sex work, the criminal and licensing laws that govern sex work, have been developed through these very stigmatized narratives around discussed around protection that are very paternalistic. They're all about risk, but the irony is that they actually place the risk onto sex workers themselves to have to manage the burden, have the burden of managing that risk on a daily level. The laws place sex workers at more risk. And so lawmakers and policymakers are often very much divorced from the context or don't listen sufficiently to sex workers, or maybe more concerned with electoral politics than the evidence base. So then we end up with these very kind of paternalistic, problematic narratives that don't actually do anything to support sex worker safety or decision making.
Yeah, and just before you go on, Jules, just for listeners, maybe people wouldn't understand that what happens in a licensing framework is a very small percentage are able to meet the requirements, or in Queensland case, a very small percentage of sex industry workplaces can, and then that leaves most of the rest of the industry outside of the legal sector and therefore criminalised. And that's what we're talking about, really, the impact of that two-tiered outcome of licensing.
Yes, in Queensland especially, where sex workers are expected to choose between either working safely or working legally, it's important, as Jules mentioned, to think about decrim as it's a range of different steps. That's not only the repeal of criminal laws and HIV and STI testing laws, or the removal of police as regulators, but also those steps around anti-discrimination, anti-vilification, the destruction of records, as we've seen in the Northern Territory, and to make sure that collectives and cooperatives of people can still work together. And we see this in other jurisdictions. We don't need caps on numbers that then invite police or invite more regulation to decide who is working in an approved or a legal way or not. We also need to make sure that people can be able to work from home without restrictions on their proximity to different churches or hospitals or other dwellings, and have agency over how they work and their working environment. So it's really important that that legislators rethink the ways in which stigma is impacting that decision making.
Yeah, and we see this playing out in law reform processes as well. Like, I mean, obviously, we see the direct human rights violations enacted by the current laws. But even during the reform processes, there's a lot of misunderstandings that drive, you know, these policies that are supposedly for the protection of sex workers, or that are ultimately for the control of sex workers. Unfortunately, you know, although there's a commitment by the Victorian government to decriminalise sex work, we've seen that play out, these kind of misunderstandings of sex work in these unreasonable kind of conditions. While a lot of those reforms are really important, I think some of those reforms are based on misunderstandings of sex work, and I think hopefully by the time that the process, we've seen that happen time and time again, around you know, who sex workers are and what they need for protection of their health. And even though we have this mountain of evidence that supports that decriminalisation is the effective model to do that, you know, there's this kind of tendency to kind of want to bring in these additional laws and these additional regulation and police enforcement, even though that's been proven as unnecessary and in fact counterproductive.
Yeah, I guess that's it, isn't it? We're seeing that in Victoria, right, where if you leave any aspect of sex work or any part of the sex worker community still within the criminal code, or like we have in Queensland, where sex worker safety strategies are criminalised in the criminal code, if sections like that are left in, then that means police will continue. They might just move to another area, start using different charges, but it does mean there's still an opening for criminalisation, and therefore we don't really have decriminalisation. So I might just move us on to a slightly different part of the paper, and your participants and the paper itself touches on criminal justice and targeted policing approaches that see Asian brothels targeted under the guise of rescue. We hear this come up a lot in the media. We see it play out whenever police are in a position to have to try to maintain their powers, South Australia being a good example. But police seem to use this issue as the basis for their need to maintain extra or additional powers frequently. And in Queensland, that includes entrapment. But the paper demonstrates that there's a payoff, isn't there, where sex workers are unable to report crime, and even if we do attempt to report crime, police often don't take that seriously. We've had some specific cases here in Queensland. Can you talk to us a bit more about that?
Yeah, particularly when it comes to migrant sex workers, and I think that's the kind of layers of stigma and discrimination, right? You know, and we often hear about experiences repeatedly from migrant sex workers who have attempted to report crimes and have not been taken seriously, or, you know, in a lot of ways, then actually themselves seen as criminals. It's often the narrative that these interventions need to take place for the protection of vulnerable migrant sex workers or as a form of rescue. However, the way it actually plays out is that we see that it's actually the sex workers who are charged, and it doesn't actually help people in that situation, in that scenario. And, you know, if it was actually a system designed to protect or support people who are experiencing exploitation or labour violations, then that wouldn't be something of police kind of raiding and people's workplaces with immigration and asking to see their passports and visas and actually deporting them. This would, you know, it's not a system that actually leads to support people who actually need that, and actually unnecessarily punishes, you know, willing migrant sex workers.
And we held a specific migrant sex worker group for this research project because the evidence shows that racism compounds sex work stigma, especially for migrant sex workers, especially for Indigenous sex workers, especially for sex workers of colour. There's a bulk of evidence now that shows the ways in which anti-trafficking campaigns have really fueled a criminal justice approach to policing, and in particular to policing Asian brothels and massage parlours under the guise of rescue. And there's a whole many books about the rescue industry as a phenomenon in and of itself. But yes, the ways in which this has meant increased immigration rates and a massive financial investment in this criminal justice approach that conflates sex work with sex trafficking, that has expanded the definition of trafficking, so consent is irrelevant, that it can't see sexual labour as anything other than exploitation. Instead of taking, like Jules mentioned, a human rights approach to labour exploitation, if our governments actually cared about migrant sex workers, they might ratify the Migrant Workers Convention. They might find ways in which migrant workers can access industrial rights mechanisms without the fear of deportation or without the fear of arrest. And so this research is really consistent with many reports over the last 15 or 20 years, including from the Global Alliance Against Trafficking Women, Asia Pacific Network of Sex Workers, Women's Network for Unity in Cambodia, Empower Foundation in Thailand, and many migrant sex worker organisations all around the world who have spoken out against the human rights impacts of over-policing and anti-trafficking, and demonstrated that this is often a problem of migration law reform. There's few safe or legal pathways to sex work in Australia, and those who do migrate for sex work often faced increased scrutiny at the border, and there's research about that, including whether people have lingerie or condoms in their luggage. So there's a range of things that could be done instead, including access to industrial rights mechanisms or translated materials for visas, so that people rely less on third parties. And I know Respect at the moment are calling for a moratorium on entrapping sex workers, and this has been a model that has been used in the United States as well, because certainly entrapment is not necessary or effective to protect migrant sex workers.
Yeah, and similarly, like the research that we did on migrant sex workers in Australia, where we spoke to over 1,000 sex workers, you know, found that this is not reality. So there's this kind of myth and stereotype of who migrant sex workers are, and this is not actually the evidence. And you know, and it was supported by the focus groups that we had done in the stigma research, but also in previous research on migrant sex workers in Australia in partnership with the Australian Institute of Criminology. And but I think, despite, as we said, even though, you know, it's the same issue, it's that stigma and discrimination overriding, no matter how much evidence that you have, this stigma and discrimination against certain, you know, communities, including sex workers and in particular migrant sex workers, persist despite the mountains of evidence that actually prove otherwise.
Yeah, absolutely. And we see that play out in many different ways in Queensland. I mean, the police have fairly openly said to us that they do target Asian sex workers, and specifically Asian massage parlours, and you know, kind of sell us this tale of, you know, people are, you know, found to have, you know, sent money back to China. So it's not unrealistic, right, for people to send money back to their families. And this concept of organised crime in Queensland, often what we're talking about, right, is us, sex workers who are communicating with each other, working in pairs, having receptionists, etc. So yeah, hopefully we'll get to talk more about that as the laws are reviewed. But I'll just take us on to consent, because I notice in your paper that non-payment is raised, consent in relation to non-payment is raised, and particularly in relation to cases in the ACT. There have been very few successful cases in other jurisdictions, including Queensland. Yeah, talk to us about that a bit.
Yeah, look, there is it is good that these cases now are kind of belatedly acknowledging sex workers' body integrity and the ability to be able to place limits on our consent in very specific and transactional ways, and also that they are taking seriously fraud when it's committed against sex workers. Numerous states in Australia now are reviewing their sexual consent laws with a focus on the fraudulent non-payment of sex workers, and so this is an issue that is gaining traction around the country. I think the lack of successful prosecutions or charges relates to a few different things, including the different legal frameworks and thresholds in different states, also lack of police understandings about sex work and the avenues that they have available to them, as well as what we've already discussed around the criminal and licensing laws as barriers to reporting in particular. But the case in 2015, Levis in the ACT, that was really notable because the judge at the time made it really clear that this was definitely an offence that ought to be considered rape rather than simply a dishonesty offence, even though dishonesty was a major factor in that situation. And she also said that sex workers clearly fall into the category of what she called vulnerable workers, who were particularly vulnerable to this type of abuse. And she remarked that the defendant had abused the trust that the complainant had placed in him. And this was cited, and similar remarks were made in a subsequent case of Minot, also in 2020 in the ACT as well. So this is an example where judges' decision making is setting precedent. But I think what's notable is that in Queensland, so there have been some very similar factual scenarios that have not resulted in the same charges. So in 2018, there were 2 sex workers in Queensland who had an almost identical factual scenario where the client had left an envelope of paper in the sex worker's apartment, but instead of being stuffed with paper, it was empty, and another where the client had remarked that he had forgotten his wallet. But in those cases, they were not charged with rape, but with fraud. And as a result, he was only ordered to pay $350 in restitution to each woman, and then was fined $750 for each offence. So I think what's important to remember is the relevant charge is always determined by the police officer who's responsible. Every state has different levels of criminal liability regarding fraudulent sex, the most permissible in New South Wales and the most restrictive in the ACT. Also, every state will have its own guidelines for charging and prosecution by the Department of Prosecutions. And that means that a very similar set of facts and circumstances might lead to different charges and different penalties and different outcomes. And although there are different avenues in which you could charge this kind of offence in Queensland, it doesn't always represent or recognise the total criminality of offending. Jules might like to speak a little bit more to that, but the other thing that I'll mention in this respect is also that in the law reform processes in many different states, sex workers have also raised the issue of police and private investigators being charged with fraud as well. And this was something that was very strong in SWAP New South Wales submissions, who have referred to this practice as government-funded rape, where private investigators have been hired by local councils to prove that, in particular, Asian massage workers are providing full services and then entrapping or arresting them or reporting them. And so there is a push also to recognise that this is not just a practice by clients, but it's also a practice by police and a form of state-sanctioned violence against sex workers.
Yeah, this is something that we unfortunately see happen all too frequently. And, it needs to be understood that in a sex work setting, consent is obtained on the basis of a range of conditions that's pre-negotiating, including that the payment will be made. And if payments withdrawn or not made, then those conditions of consent have not been met. But, as Zahra highlighted, that there are a number of barriers to sex workers reporting these cases. And we've heard a number of times from sex workers who have, managed to surmount those significant barriers to reporting that rape or sexual assault, and have been then told by the police that they don't see the crime, or that it's a civil and not criminal matter. And this is something that happens regularly. And I know that Respect have been progressing formal complaints about this behaviour in Queensland. But as Zahra was highlighting, that it was also kind of recognised in the review in Queensland, where the QLRC report recognised that property fraud doesn't actually acknowledge the totality of the criminality of the offending, the totality of the offending. And this was also noted in the closing statements by the justices in the ACT cases, acknowledging that, that I think, and it was interesting in the Leavers case that Justice Penfold spoke about how Leavers and his counsel continued to try and minimise the responsibility and not show remorse and minimise this as a kind of, act of sort of property fraud. And unfortunately, the laws are still doing that to most sex workers in most jurisdictions, including in Queensland.
Yes, it is very unfortunate. So we might just, we've only got a few minutes left, and we might just touch on the paper in relation to anti-discrimination and anti-vilification protections and expunging sex workers' historical convictions. Any thoughts?
Yeah, look, this is such a necessary part of the decriminalisation process. And as decriminalisation of sex work's been kind of looked at or reviewed or undertaken in multiple jurisdictions as a necessary change for protecting the human rights of sex workers, it's also clear that as part of that, mechanisms to address discrimination and vilification, and also to kind of, expunge those previous registration records or previous criminal records for sex work, similarly to when homosexuality was decriminalised, should also happen. And this is an essential change to facilitate sex workers' access to the benefits of decriminalisation. So in Northern Territory, amendments to the anti-discrimination legislation has been considered with the inclusion of review process of sex work and sex worker into the anti-discrimination and vilification process being considered by the government. And also the kind of expungement of those records once the registration was repealed happened in the Northern Territory and also in the ACT. Unfortunately, in Victoria, they are repealing the registration system, but are proposing to keep the registration records as a historical record. And this is being argued in the upper house to amend that, as if you recognise the harms of registration, it's important that those records that continue to haunt somebody and remain criminalise somebody must be also expunged and destroyed.
And Zahra, last little short comment.
Yes, well, I'll just note that there are a number of different frameworks for anti-discrimination around Australia, but they are very ad hoc. So we have some limited protections in Tasmania, Queensland, Victoria, and the ACT. But the ACT is focused on profession, which is almost too broad to cover sex workers in every instance. And we have lawful sexual activity, which is clearly a problem with the existence of criminal and licensing frameworks. And in Queensland in particular, the protections that did exist were repealed in 2012 or 13 when a sex worker tried to exercise her rights and take a motel to court for discrimination from a motelier, even where there was no evidence of any amenity impacts. And the Attorney General stepped in at that time to say that moteliers should be able to decide who stays at their accommodation. And we now have this section 106C of the Anti-Discrimination Act in Queensland, which means that sex workers can be discriminated against. The terms are extremely broad and even could allow for sex workers to be evicted from their own homes. So that's a real problem with the existing laws in Queensland. In particular as well, section 28(1) allows discrimination against sex workers who are involved in care or instruction of minors. But we know that sex workers can be excellent youth workers, many are parents, workers, care work. So there's a lot to do to reform the anti-discrimination law in Queensland. As Jules mentioned before, we have pending changes in New South Wales, which are very specific about the terminology of using sex workers. But what's important, particularly for Queensland too, is that there are still barriers for the process that mean that sex workers have to use a legal name, which we know can lead to misuse or doxing or stalking or harassment. Often anti-discrimination settlements require a non-disclosure agreement or gag clause in settlement, which limits its precedent value for other sex workers. So we need to be thinking about ensuring that sex worker is there as an attribute, that sex worker organisations can make complaints on behalf of sex workers as groups, that people can make complaints anonymously, and that there are no financial barriers to sex workers making complaints if they do have to progress that further at QUT or the Supreme Court. So, and I have just put a link in the chat for a further research project we did. There were further findings that came out of this study that was about mental health and stigma. And one of the findings was that we require anti-discrimination protections.
Oh, thank you, Zahra. That's a very important point, and I think a good place for us to leave today. Thank you both so much. It's been really good to hear about the research project, about the paper, and to read it in its entirety. I very much would recommend everybody who's on the call to have a look at the link and please read the paper. There's very important aspects of that we haven't got to cover today, but thank you to QUT School of Justice and DCRIM QLD, and of course Scarlet Alliance, Jules and Zahra. Thank you so much, and we'll say goodbye.
Thank you so much for having us.